Morning and welcome to all our participants and viewers this morning. My name is Chantal D'Souza and I'll be coordinating the webinar today. We've got a very exciting topic on the criminal justice system and HIV/AIDS, which I think hasn't been discussed for a while amongst civil society and pro bono lawyers. So if I can just take this opportunity to introduce our speakers. We've got Kimi Bihari, who was a former magistrate in the criminal courts, Sheena Schwemmer from the Center for Applied Legal Studies. She's the head of the gender unit. And then Emily Craven from SWEAT. And then if I can just hand over to Teresa Yates from probono.org, who is hosting this project.
Thank you, Chantal. I just want to take a few minutes to thank everyone for taking out time in your busy schedules to attend this webinar. And for those who'll be watching later, to thank you for taking some time to watch the recording. This webinar is part of a series of learning events that probono.org is organizing to raise awareness around discrimination and stigma related to HIV and TB in South Africa. And we all know that often the criminal justice system does not always deliver justice to people who are most vulnerable within our society. And often HIV and AIDS and TB contribute to or exacerbate existing vulnerabilities within communities and people who live in South Africa. So we're very happy today to have a very distinguished panel to give us information about some of the challenges within our criminal justice system and sort of focus us towards some solutions to some of these challenges, as well as perhaps, I hope, give us a little bit of insight into some things that just might be working well here and how we can build on those. So Pro Bono is happy to welcome you all here, and I'll hand it over back over to Chantal and the speakers now. Thank you.
Thanks, Teresa. So we're going to start off now with Kimi Bihari, and he'll be giving an overview of the Sexual Offences Act.
Good morning all. I hope I'm loud and clear. So for today, Chantal, am I audible?
Yes, we can hear you.
Okay. All right. Thank you. So thank you for the invite. For today, given the space that we have, I've decided to do a sexual offences cluster dealing with the areas of interest. And of course, all legislation and all issues of legislation dealing with methods of sexual violence and sexual offences, it's important to go back to the Constitution, because very often you will be having a balancing of rights that needs to be done, looking at the non-derogable rights as opposed to other rights and the limitations in Section 36. So you'll see the focus of this is the Chapter 2 and the Bill of Rights, because you will be getting competing interests. You'll get the, if you look at on the top orange layer, the Criminal Law Amendment Act, Sexual Offences Act. What this has basically done is brought into one umbrella legislation, fragmented pieces of legislation that dealt with primarily in the past rape, indecent assault, and brought it into a category where you have far more areas dealing with bestiality, pornography, and other offenses which have been brought into this legislation. So in that respect, but you can always look at, if you look at the HIV status aspects, that when it comes to sexual offenses, the HIV status, both of the perpetrator and the victim, especially who could have been infected after the assault, are paramount. Then, of course, we have the general perceptions on HIV status, TB, what are the implications for persons living with HIV and those in terms of stigmatization and other issues. But to go back to the Criminal Law Amendment Sexual Offences Act, and as I mentioned, is you have a whole lot. I've prepared a PowerPoint, which I've also sent through. But I thought for the purpose of today and the space we have is that I focus on the cluster of legislation that's applicable. Now, of course, for offenses of sexual offensive nature, the act that I've referred to is applicable, but at all times and even later on during the evidence and if it's a conviction and when you come into a sentencing, the issue of HIV status at the time when it was applicable becomes of paramount importance, especially given the firstly the issues of the bail, how bail in terms of your Criminal Procedure Act deals with it as a Schedule 6 offense, and then furthermore when it comes to sentencing in terms of the criminal law sentencing legislation as to how minimum sentences may be applied for in those circumstances. So the CLA Sentencing Criminal Law Amendment Sentencing Act is to be closely read with the Sexual Offences Act and must at all times be considered against the HIV status of especially the perpetrator, but more especially the victim as well, in terms of aggravation and mitigation of sentence. In terms of the next one, it's actually a cluster legislation dealing with related offenses, because sexual offenses happens in many environments. You may have it arising out of an organized crime situation. You may have it arising out of where sex workers are forced to perform unlawful acts on maybe police officers, investigators. These are all linked to corruption. And then the evidentiary issues, which we're dealing with the Prevention of Organized Crimes Act, FICA being a related legislation to looking at the overall organized crimes body of legislation, being the Financial Intelligence Center Act. Then you also have the evidentiary based legislation, which is your Electronic Communications and Transactions Act, especially if it's needed in that environment where sexual offenses are committed out of organized crime, to look at the evidentiary material and the gathering of that, read together with the regulation of interception of communications, where communication instructions or directions may be obtained in order to tap certain calls or obtain certain information. Of course, together with poker and organized crime, you get the related legislation with the terrorism, where very often these are funded by organized crime. And then your drug trafficking and your Trafficking in Persons Act, which is also applicable in terms of looking at holistically, where persons are trafficked and then forced into sexual misconduct or conduct that constitutes then an offense of rape, where the person is forced into such an act. And then the cybersecurity bill, of course, we were looking at it because it'll have an impact on the Electronic Communications and Transactions Act in terms of evidentiary material and how to access certain information. So when you go down, then you're looking at court judgments. Now, as far back as one of the cases I've got was the Magira judgment, which was in 2005, with the issue of the HIV status, and how it should be dealt with, must be dealt with, where this an ordinary person sentenced for a crime committed unrelated to sexual offense, they looked at how the HIV status should be considered when you're sentencing it. Does it form a mitigating factor? So the rules have been laid out from then. To go then further into other cases where the victim became positive with HIV AIDS after the sexual assault, and how that would serve as an aggravating factor. The most recent cases which I've got, which I covered here, was a CN versus a state, where it just shows the difficulties some of the witnesses or the victims go through in an actual court scenario. And this is more so emphasized when victims are either a minor or somebody with some form of intellectual disability. In terms of that, how much more difficult it is to obtain the relevant information and the evidence in court. And if in a reading of the CN versus a state case, which was an appeal where the magistrate convicted the person and sentenced him to life imprisonment. It was on appeal. The judges upheld that judgment because of the findings of fact based on the accused person knowing or having knowledge of his HIV status before he committed the act, and also to link to the Criminal Law Amendment Sentencing Act, where the offense of sexual offense happened more than one occasion on the same person. So to move then to the green aspect, which is the Criminal Procedure Act. So this act deals with the procedure, the enrollment of the cases, deals with the inception from the bail or after arrest for your bail, and how certain sexual offenses are to be treated when you're granting bail. That is, those that are in terms of Schedule 5 and those that are in terms of Schedule 6, linked to Section 60 of the Criminal Procedure Act. The controversial issues are, and which I've experienced personally, the delays in prosecution. The delays from when the incident happened to when the charge is instigated, or to the different proceedings for further examination or further obtaining further witnesses or further investigation, to certain delays that attorneys can impose in the entire process for one reason or the other. Now, what happens in these delays? You have an impact on the victim. You have an impact on the witnesses, the recollection ability. In terms of here, we have a thing called the cautionary rules. Especially in many rape matters, you may not get many witnesses. So the only person is a victim and the perpetrator who are witnesses to the incident. So we have to look at ways in which we're dealing with it so the matters can be expedited, especially where children are involved, and especially where persons with intellectual disabilities are involved. So the Section 342A proceedings in the Criminal Procedure Act must be used more often, and where there's delays which are inordinate. Again, for legal practitioners and all persons in court, we must make use of the in-camera proceedings, the closed-circuit TV camera proceedings, the intermediaries testifying through intermediaries, and also interpreters. Now, when it comes to interpreters, especially sign language interpreters, you may have to also look at the added stress caused by relay interpreters who interpret from one dialect to another. So these are also important aspects in the entire value chain dealing with sexual offenses, the prosecution thereof, or the defense thereof. Colleagues, an area very close to my heart for many years is the social context of this entire. We always ask, I've read many articles as to what causes people to engage in gender-based violence. We've heard recently with the COVID, the minister saying, no, it's alcohol-based, but it can't be so simple. These are steeped in historical presence of patriarchy, colonialism, steeped biases, stereotypes, religious intolerance. So these are all aspects where you need a proper investigation, and perhaps going back to our communities and linking with the green aspects on the actual procedures, together with investigation. The local governments and the government at local government level must be more involved. They have access to the schools, they have access to universities, they have access to what's happening on the ground. Where are the criminal syndicates? Where are the people being trafficked? Drugs being peddled. So the local government and law enforcement at local government, have to be more involved, pushing more for cases to be proceeded and finalized without delay. Fortunately, in the area where I'm sitting now, the city of Ekurhuleni, We also have a program from the mayor's office dealing with victims of crime, and where we also look at court appearances, support to the victims. In terms of why are the delays? Is there any corruption involved from investigating officers? Is there anything delayed corruption from the prosecutions? We don't rule out anything. And unfortunately, we have to have a hard-nosed approach when you're dealing with issues of sexual violence, and that goes to the issue of the Criminal Law Sexual Offences Act, creating minimum sentences for certain types of offences and lesser for others. Colleagues, we have to go back. A sexual violation of any nature is a very personal violation. It causes trauma. You cannot say that one part of it is much more easier to take on another type of offense. It is a very personal violation, and only the person who actually has to go through that will actually know for years how they will deal with the matter. And then, fortunately, recently on the 23rd of December, we had the prescription in criminal and civil matters arising out of case law, where the former statute of limitations, as it was removed in terms of certain offences such as rape and so on. So I think I don't know, I'm doing for time. I'm sure I'm within the time there. But colleagues, this is where the cluster needs to be looked at. So when we're looking at any sexual offences, it is important we consider holistically the impact on society, the impact on the victim, the perpetrator, so that we don't have issues of leaders in the community or in the country saying that intelligent men or educated men don't rape. We don't have people give us statistics and seem unworried about that, where 16 or 18,000 people rapes happened in the last 3 months. But what is it going forward? What are we going to do about that? How are we addressing the budgets available for addressing this? How are we looking at budgets at national, provincial, and local government to address these issues? And how is the law enforcement at local government, who are in direct link to where the incidents and the criminal offences occur, to participate and assist with that? So I've said a mouthful, colleagues. I hope, I think we will, Chantal, if we can hand over to you. I think I'm within that 15-minute period. But if there's anything, we'll take on questions a little later. Thank you very much.
Thank you, Kimi, for that very comprehensive overview. And I think you've touched on very critical questions there about what do we do moving forward. And also the whole point of these webinars is to create awareness and to get victims using the law and make lawyers more aware of what is available. I'm now going to hand over to Sheena Swemmer, and she can take us through some of the work that the Centre for Applied Legal Studies has been doing in respect of HIV/AIDS and the criminal justice system. Sheena.
Thank you so much. Let me just get my document ready. So thank you so much for having me. The question that I was asked when preparing or to prepare on for this seminar was the rights and protection of victims in respect of HIV/AIDS, and do we require a more victim-based approach in the criminal justice system? So recently, 2 weeks ago, the Centre for Applied Legal Studies was an amicus, a friend of the court, in the constitutional case of AK versus the Minister of Police. And this case did deal squarely with the idea of a victim-based approach. So what had happened in this case is the appellant, the individual woman, was kidnapped and raped on a beach in the Eastern Cape about 10 years ago. She was held for quite a while by the rapists, and what had really happened was that there was a failure by the police to find her during this kidnapping stage. as well as afterwards, there was failure around investigation of the case. So up until today, there's still no one that has been arrested and no one that has been prosecuted for the rape. The thing that she did in this case was that she actually applied for damages which are based on psychosocial damages, so trauma and anguish, but which stem from the failure of the police to do their job. Rather than, so it's acknowledging, yes, that you have the trauma resulting from the actual rape incident, but this was made worse, or secondary trauma emanated from the failure to find her, and also from the failure to investigate to a reasonable degree. So interestingly, this is one of the first of these types of cases in the country that has reached this level, the Constitutional Court. And it really deals with, do the police and does the criminal justice system have an obligation to enact, to perform in a victim-centered way? And when we get their failure to act in this way, and we have psychological damages, should they pay for such things? So what the case really centered upon was the victim-centered approach to policing. And I mean, from that, we can say the victim-centered approach to the criminal justice system more generally. The victim-centered approach, as far as Cull's asserted, is three things, or among three things. The victim-centered approach to policing is specifically focused on the need to restructure your policing in order to position the victim in the center and to reduce the re-victimization. And when we say, and this is going to be important for when we look at criminal justice or the criminal justice system in general, is the movement of the victim to the center, instead of what we get when we say state versus swimmer or anything like that. Is that's the state and that's the accused, but where is the victim in all of that? And that's really kind of the issue of this, is the victim is used as a tool to obtain a conviction, but the actual psychological welfare and rights of the victim are not prioritized. And this is incredibly problematic, and the outcomes or the consequences of this are quite dire, which I'll come to just now. The second thing is the victim-centered approach to the criminal justice system more generally is a movement to the involvement of the victim in the process. And this, a lot of victims will tell you, is they feel that the investigating officer, the prosecutor, don't tell them things, don't ask them things, don't ask their opinion about things. And even in sentencing, we don't often get the victim statement, as well as when we look at convictions and when we're looking at whether the individual will qualify for parole. Victims are often not told that this process is even going to happen. So it really is both the centralizing of the victim, but also just speaking to the victim and asking what they want in a situation like this. And the final one is that the victim-centered approach to criminal justice embodies the idea that a sexual offense case is the victim's case, and the importance of framing it that way. And that really goes back to what I said at the beginning. It's not S versus swimmer or something like that. It's an individual that was harmed, and they can't be forgotten in this entire process. Excuse my binging emails in the back here. I'll just put that. There we go. So that was really kind of central to what the case dealt with, and was highlighting the fact that we really don't have this system. We don't have this system, and what I'm going to show you just now is we have the system in legislation and policy, but we don't have the system in practice. And I know you roll your eyes because this is what everyone always says about sexual offenses, is we have great legislation, but it's the implementation. And once again, we have legislation and policy, but it's the implementation. So is there policy and legislation around this? Yes. So just to be very brief about this, the legislation that really acknowledges and asserts the victim-centered approaches are our Constitution. So people have the right to be free from all forms of violence and that includes public and private violence. And secondary trauma and secondary victimization is a form of violence, and it's violence asserted by a system which is put in place to protect you. So it's actually one of the most egregious forms of violence. It's the re-violation of the victim or the survivor, whichever the person prefers to be called. The next is the South African Police Services Act. And in the preamble of the act, it says there is the need to reflect respect for victims of crime and an understanding of their needs. And we also have the Sexual Offences Act, which my colleague has just spoken about, where the preamble says making provision for the adoption of a national policy framework regulating in all matters in this act, including the manner in which sexual offences and related matters must be dealt with uniformly in a coordinated and sensitive manner. So we have statute that acknowledges that there is definitely something that has to do with victims and needing to treat them in sensitive ways and needing to listen to them. But then we have policy that comes in and really bolsters this. So we have our Victims Charter, which provides things such as giving information to victims about the status of the case, which doesn't happen. But it also has provisions around sensitivity and listening to victims, being cognizant of families, because sexual violence doesn't only affect the victim or the survivor, it affects the entire family too, and the community in many ways. We also have national policy guidelines around sexual offences, and we also have a SAPS national instruction. And these documents are very interesting because they almost set out stage by stage what the police do when the person initially comes to them to report a rape, but also investigation. And these are filled with very victim-centered approaches. They speak about giving the victim time. They speak about not interrupting the victim when they are telling their story, but we don't see this in actuality. The final policy, which I said policy, but should actually come under legislation, is the Victim Support Services Bill, which would probably be the type of bill of your victim's rights or your victim-centered approach. And we're still waiting for that to come into law. But I think it's worth going and looking at this document because it also has very problematic provisions within it. And then case law around this we have things like Carmichael. And in Carmichael it was said, South Africa has a duty under international law to prohibit all gender-based discrimination that has the effect or purpose of impairing the enjoyment by women of fundamental rights and freedoms, and to take reasonable and appropriate measures to prevent the violation of those rights. So there is an actual positive obligation on the criminal justice system to adopt a victim-centered approach. So I'm going to, because I want to keep it within the time limits, I'm going to say, why are we not seeing this and what happens when we don't see this? So why are we not seeing this? Why are we not seeing the actualization of these laws, policies, and jurisprudence? So as I said, for the most part, this is already entrenched in our law and doesn't need to be inferred from something like the Constitution. It is, at this point in time, it is not being prioritized and it's not actually substantive in the way it's used at, or if it's used at all. So it's another process of either a process of it not happening or a process of a rubber stamping exercise with no actual understanding of why you would need this. And in a lot of ways, with the police, with prosecutors, with court staff, with judges, with magistrates, is the lack of understanding. But as my colleague pointed out, is the discriminatory views we have and patriarchal views. I always say that our judges, our prosecutors, our police come from our communities. And when our communities have discriminatory views, why do we think that our judges aren't going to have the same? So it really is both a top-down approach and a bottom-up approach of understanding why discrimination is very problematic and why patriarchal views are problematic. So those are some of the reasons we don't actually see the victim-centered approach playing out, despite the fact that these are acknowledged in our law. If you don't understand it, why would you want to do it? If you don't understand how egregious it is, why would you want to change? But there are really reasons why we should change. And there are maybe three very important reasons. And this is what we had submitted as culls in that case above, is that when a victim or a survivor sees or hears that other people have experienced terrible treatment by police that is discriminatory, that is harsh, that is not focused on them as individuals, that is uncaring, they will not report sexual offenses. And we already have a really dire situation of the lack of reporting. It was 1 in 9. The Gauteng study says 1 in 25. So there's no reason for people to want to come forward if they don't see that they're going to be treated in a way that is going to be mindful of their well-being, and that might lead to secondary victimization or traumatization. The other thing is that when victims or survivors have reported a case and they get treated in such a way at the first stage, they may not want to continue to the next stage, such as prosecution. They might say, the police treated me like this, there's no way I'm carrying on after that, and the case disappears, which you can't blame people for wanting to do, because having to be traumatized by a rape incident and then re-traumatized by uncaring officials is a mentally taxing and also a real attack of the self and the safety of the self. And the final thing that that really happens and is a problem with these kinds of failures to take a victim-centered approach is something we call attrition. And attrition really means that when we look at rates of attritions with sexual offenses is, what is the number when we start, when we see reports of sexual offenses at the police? What happens to that number when it goes to investigation? What happens to it when it goes to prosecution? What happens to it in conviction? In South Africa, the MRC study found that of these initial reports of rape, only 8.7% result in conviction. So I don't need to explain that much more than that, is the attrition rates is exceedingly high in the country. And one of the reasons is that people do not trust the criminal justice system, and people are scared of it, and people are traumatized by it. So the reasons that we have are not only those about respecting the individual, those of individual rights, dignity, equality, rights to safety in our country, but it extends to all victims and all survivors of sexual offenses. Is that when I don't get the type of treatment I deserve as a human being, I tell people that I didn't get it, and people don't want to try either. So there's going to be no change in our attrition rates if we don't try to change the way we treat people who come forward around sexual offenses. Thank you.
Thank you, Sheena. Yes, once again, we have to thank CULS for being on the cutting edge of legal development. Just a reminder to all the participants, if you would like to already put a question up, then you can always just put it in the chat. Otherwise, we will have the Q&A session once Emily has spoken. And then you can just use the, if you click on participants, and you can just raise your hand, and then we'll know that you want to speak. So just on that, I'm going to hand over to Emily Craven from SWEAT, and she will be discussing the continued criminalization of sex workers. Emily.
Just get in the view. Brilliant. Thank you so much for this opportunity. I should say up front that my presentation here is on sex workers and their experience of the criminal justice system. I will focus on some HIV specific stuff, and given the massive incidence of HIV within sex worker community, It is, in essence, a presentation on the impact of, well, the effect of the criminal justice system on HIV positive people. But because my area of expertise is sex workers, that's what I'll speak about. And this is about sex workers' experience of the system, regardless of their HIV their status. We can tease out some of the issues around that, perhaps, in the Q&A. I wanted to first off acknowledge that we do exist in the context of full criminalization. It is a criminal offense to both buy and sell sex. Historically, there's been a bit of a hodgepodge of bits of legislation that have criminalized various aspects of sex work. It's sometimes quite hard to make sense of, partly because different bits of legislation covered different things, you know, so there'd be one law that made brothel keeping a crime, but you know that selling of sex itself wasn't. There was also the constant use of weird euphemisms that may have made sense at the time, but now just seem sort of archaic and weird to criminalize sex work. But that said, in 2007, as we've had a bit of an insight into already, how sex work fully became a crime, both to buy and sell sex. That said, there is still a level of vagueness around the terminology. The has unlawful carnal intercourse or commits an act of indecency with any other person for reward is bizarrely vague, to the extent that if one was particularly zealous, almost any kind of form of transactional relationship could be considered sex work. It doesn't say the reward has to be financial, for example. So there is still a lot of space for misunderstanding, misinterpretation, not really being entirely sure what is and isn't illegal. But nonetheless, I think the message is very clear that sex work is criminal. And this has a couple of impacts, obviously, immediately in terms of the conversation that we're having here today. The one is obviously, and this is something that we've kind of found in our work, is that sometimes it's hard to get legal professionals on board with engaging with sex work issues, because regardless of their personal feelings around whether sex work should be a crime or not, they recognize that it is a crime, and therefore, you know, their pro bono mandates, for example, don't always extend to working with sex workers, also because, you know, it's still quite a divisive and controversial issue. Another issue kind of specifically related to HIV is that we have this weird disconnect within the structures of governance that, from a public health perspective, and particularly an HIV response perspective, sex workers are considered a key population. The terminology of key population is one that anyone who's worked in the HIV sector will know. Some people find it very kind of problematic. Other people have quite happily adopted it, but key populations are sex workers, people who inject drugs, essentially any population who have a particular vulnerability to HIV and are considered to some extent outliers in the mainstream response to HIV, which has become more of an issue as sort of statistics on movements towards the 1990 targets for HIV have got much closer. The question is, who are the outlying populations? And of course, that has a lot of potential for discrimination and stigma wrapped up in it, but it also does mean the provision of dedicated services, which, you know, has had a pretty positive impact. But what this means is that sex work activists find themselves within very prominent roles within the public health response, hold very high positions within SANAC, are often invited onto panels when, you know, government ministers, even, you know, the president is speaking on issues of HIV and AIDS, which is a really bizarre situation. I mean, you could literally be on a panel with the president one day and arrested the next day for exactly the same thing. Essentially, the thing that you are being arrested for is the very reason that that you're considered important and influential within the HIV response space. So there's a weird kind of contradiction there that everyone can kind of see, but there hasn't really been any steps to remove. So a couple of things to note. One is that sex workers have a very fraught relationship with the criminal justice system. Very few sex workers will tell you they've had very positive engagements with the criminal justice system. And a very high proportion of that is with the police. So many times sex workers get no further into the system than at the level of their interactions with the police. Very few people are ever actually arrested and charged with sex work as an offense. It's hard to prove in many cases, and in our experience, very few police officers even understand in what form the crime exists, what the burden of proof is, any of those details. They just have a sense, they know that, sex work is a crime. The exception to this would be raids on brothels, for example. But even then, there's a lot of grey area. You'll find reports of 40 women, 40 human trafficking victims rescued from a brothel, for example. Meanwhile, we'll know that those 40 human trafficking victims who were rescued are in fact 40 sex workers who are trying to get out of a police cell as we speak. So the point is that sex work as a crime is very rarely actually followed through into any kind of court process. What tends to happen is that sex workers are rounded up using bylaws. So bylaws against loitering, soliciting, homeless targeting bylaws. They're often arrested for drug-related offences, and often they are arrested, being told they're being arrested for sex work, but with no intention to actually sustain that charge post the police station. In many cases, they're held for a few days, asked for a fine or a bribe. It's never entirely clear which it is. Bribes being both paid in financial terms, but also demands for sexual services. And then usually released on a warning. Where people do find themselves in court, cases are normally dropped immediately. So very much it's clear that the punishment is in fact the process of arrest, exploitation, and eventual release. That is kind of the punishment. The court system largely doesn't ever come to engage with these cases. So what you have is essentially profiling, sex workers being profiled, being rounded up, some level of exploitation, a lot of power play, often violence, often rape, and then let go. And now, in some ways, this has become a cycle that many sex workers have become quite used to. Some will laugh it off. They'll say, "Oh, I spent the weekend in the police cells," But for others, it remains a point of enormous trauma and violence. And we know that there are cases where it goes horribly wrong. And I'll speak a little bit in a while about the Robin Matsumi case. A couple of things just specifically to HIV-related issues, though, to kind of bring us back to the topic. Sex workers who are arrested without their medicine on them are often denied access to the medicine for the number of days that they are in police custody. This has major impacts because if it goes on for long enough, they could be considered to have defaulted on their medication, forcing them into a higher level regime of medicine, which becomes a cycle of defaulting because it becomes harder and harder to adhere to your medication. The second thing is I want to touch on here is the use of condoms as proof of sex work. So in another one of those strange contradictions, you have the Department of Health handing out condoms specifically to sex workers, and then you have police officers using the presence of multiple condoms as evidence, and I say evidence in inverted commas because it's not evidence that's actually really expected to play any evidentiary role in a court case, but using that as a basis on which to arrest them. So yeah, those are just a couple of specific HIV related. The second thing is that it goes without saying, or it should go without saying, that being arrested for sex work or any other offence does not mean a blank check for the behaviour of the police involved. And that's true regardless of what it is that you've been arrested for. But police often work on the assumption that sex workers will either be too scared to speak up against abuse or violence, that they won't want to acknowledge what they were doing when they're arrested, and therefore will go quietly, or they fear rejection from partners or families if they are outed as sex workers, and therefore they'll kind of take whatever treatment is meted out to them and go quietly. Arrested sex workers fear theft, rape, violence, disclosure when they're in police custody, and feel like when the cell door closes, there is very little protection. Just to mention Robin's case very quickly, Robin was a sex worker who lived in the Mowbray Observatory area of Cape Town, who was arrested in a sweep during the lockdown. There's a lot of kind of uncertainty around the manner of her arrest, but it seems to be linked to her refusal to go to the Strandfontein camp. She was arrested and charged, well, not charged, she was arrested for drugs-related offences. She was taken to the police station where she died some days later. The circumstances of her death are mired in secrecy. The IPID report on her death has never been released. The Human Rights Commission has been trying to get hold of that report for some time. But essentially, she went into the police station and never came out. And nobody has been held responsible. The police claim that she committed suicide. Nobody really believes this claim for multiple reasons. Some people believe that she was murdered in the police station. I think the more dominant idea is that she was just very badly neglected, went into drugs withdrawal and died without anyone noticing. In fact, it was several days. Only when a detective went in to speak to her was she found dead. The police who were working at the station were unaware for some days that she had died. So that's the kind of worst case scenario of sex workers and their experience of the criminal justice system. What this does mean is that when sex workers are the victims of crimes, and I've sort of said perpetrators versus victims, but again, perpetrators in big inverted commas, because, you know, certainly we don't consider them to actually be perpetrators of a crime. But when they are victims of crime, the chances of sex workers trusting the police are extremely low. When sex workers approach the police at all, they're often subject to extreme secondary victimization. There's a sense that sex workers are not good victims, that they have in some way been responsible for their own victimhood. And beyond the police, sex workers who are murdered, for example, are often unnamed. So the media will often not name a sex worker. They'll simply be a body on Baden-Powell. They're not a priority for investigation. And yes, so people's deaths just disappear. It's not unusual, even to this day, to have a situation where there'll be a claim that you can't rape a sex worker because, you know, they're sex workers. So obviously rape is not a thing. As recently as I'm thinking a high profile case like the Buyisiwe rape case, which is about 10 years ago now, the defense did make the argument that that the accused believed that because she was a sex worker, they were entitled to have sex with her whenever they wanted. Thankfully, the court kind of absolutely rejected that situation and that suggestion, and they were all, found guilty of rape. But the fact that that argument is still kind of sustained, and we hear it to this day, the idea that if you hadn't been working, you wouldn't have been raped. So, why should the resources of the criminal justice system be kind of given over to you? So yeah, and obviously ranking of victims by virtue is never acceptable, but it's particularly grievous to sex workers because, they will know that they will never be at the top of such a ranking. In fact, they will always come kind of at the bottom. So yeah, I wanted to just kind of end by reflecting that criminalization does lay the groundwork for all of this. The fact that very few people are kind of ever charged with sex work has made some people say, well, is the decrim campaign then just a bit pointless? Like, I mean, if you removed all those statutes in law that criminalize sex work, you would still round people up for bylaws violations. People would still be arrested and held for a few days and then released. But our argument has always been that it is the criminalization that lays the groundwork for the stigma, for the discrimination, for the assumption of impunity with which violence against sex workers is perpetrated within the criminal justice system. It's the fact that sex work exists within the shadows and is kind of seen as being somehow part of a criminal underworld that immediately sets you up for a level of violence that is almost, you know, your own fault for getting involved in, is what allows for sex workers to be abused within the police system and for their deaths outside of it to go unnoticed and unrecorded. So criminalization is the foundation for the sex work experience. And I think the linkages to HIV, I mean, there are many, but I think perhaps that contradiction that I spoke of right at the beginning, of the ways in which sex workers are seen as being absolutely key to the country's efforts to break the back of the HIV pandemic, are seen as you know, important as a political voice, as an advocacy voice in tackling the pandemic. And yet, you know, the moment they step down from that platform, just become criminals who have no rights, who were asking for exactly, you know, what they got and who could be murdered tomorrow without anyone noticing, is such a grievous dislocation that it really does point to how ridiculous ongoing criminalization actually is. So yeah, I'm going to leave it there.
Thank you, Emily. I'd just like to know from the participants whether anyone has any questions for our speakers. So that's Kimmy, Sheena, and Emily. Are there any questions? So I have one for Emily. You said in your presentation that there's a reluctance for legal practitioners to work with sex workers because it is still seen as a crime. So basically the objective of this project with pro bono is that we get more pro bono lawyers to actually work around these issues of HIV/AIDS. And you've obviously highlighted that sex workers are part of the key and vulnerable population. So what do you think that we can do as pro bono together with civil society and the lawyers to actually get more lawyers to take on cases and to be more sensitive to the issues?
Oh, that's a big question. I'm sure we have a shopping list, but yeah, I mean, look at, and just to say, it's the ongoing criminalization, but it's also the stigma. It's also the fact that, you know, many people do have kind of moral problems with sex work, and you know, lawyers, you know, are also, you know, part of society. So I mean, someone said the question, why wouldn't the police share the morals of society? I suppose one might argue with, you know, why wouldn't lawyers? That said, there are amazing lawyers out there who have consistently supported the DCRIM program and the rights of sex workers. So yeah, it's not a lack of willingness to support. I guess it's more, I suppose, a willingness as a sector to take clear positions that just because sex work is illegal does not mean that pro bono lawyers should not be allowed to use their hours on sex work related cases. I know that small kind of independent lawyers tend to not have those issues, but those who work in for big firms often will say to us, look, we're really sorry. I personally think criminalization is terrible, but my principals won't let me you know, work on something that's illegal. And as I said, the people who inject drugs, another major sector within the public health response to HIV, tend to have exactly the same problems. So if they try and get some pro bono help for, say, an effort to clean up a suburb of drug users, which actually is, violent and repressive, the lawyers involved will say, but, don't we want to clean up suburbs of drug users, kind of thing. So it's about kind of looking past our immediate moral sense of right or wrong and asking ourselves, what are the individual acts of repression and violence and the sort of the removal of basic constitutional rights that are happening behind what we're seeing here. And yeah, if more kind of people want to get involved in kind of decrim legislation work, that's something we're always keen on as well. We've kind of tended to back away from that a little bit, in part because of the previous Constitutional Court case, the Kiley case, which was lost. It was not a great case. We were almost forced to take it on because of circumstance and because someone had brought the case. But it has made it very difficult to see a pathway back to the Constitutional Court to engage with criminalization on that level. And so lawyers that we've worked with have looked at all sorts of levels. One of the most promising being, the question of whether sex work actually meets the base criteria to be considered a crime in terms of its, who the victim is and all that kind of stuff. So, any lawyers who are keen to get involved in that would be great. As I said, we've backed off for that reason, also because, progress with government on a legislative solution had seemed so good. And so much commitment had been made to decriminalization that it felt maybe aggressive to be kind of pursuing a legal strategy at the same time. But I think we've all reached the point now where we're saying, actually, this kind of legislative approach is not working. People are willing to say on public platforms that they support decrim, but they're not willing to actually, push any kind of decrim bill through Parliament. So yeah, we're exploring again, kind of going back to looking at some of the legal options, and anyone who wants to get involved in that is very welcome.
Thank you. Are there any other questions? Sheena, I just have a question for you, just on what Emily touched on. So since that Constitutional Court case wasn't successful to decriminalize sex work, how do you foresee any way of sort of bringing another constitutional challenge on that? Because Emily says it's going to be a very difficult path. And I know Carl's has taken on a number of these sort of pivotal cases.
Yeah, so I was actually just thinking of that. And what's interesting is that last week we saw the revisiting of Folks v. Robinson's, the case of domestic partnerships and maintenance. And that had previously been declared by the Constitutional Court that it wouldn't apply for heterosexual couples. And last week it was in the Concourt, last week was in the Concourt, challenging the Concourt's previous decision. So I don't think all is lost with regards to actually, although this case did have an extra part which challenged another act, they did head on challenge the previous decision of the Concourt by itself. And I think this case will be very, this particular cohabitation case is going to be very successful. I really do. I really think it's going to change. So I do think there are some nuances that can be approached in making a new case, but I don't think that the idea that the Concourt can't ever overturn blaringly wrong decisions around things that were historically made in maybe what people may say a very different time. I don't think we should be afraid for them to reconsider cases, which they've done last week. And I really do think that that case will change their previous decision. So I think there's definitely room for creative lawyering, but I also think there's sometimes times when we can reapproach the Constitutional Court and say, times have changed. We have all this development around us, and all these studies around us, and all this information about the harm of criminalization, I think maybe you guys made the wrong decision. So I definitely think it's something worth exploring.
Okay, great, thanks for that. And then just to Kimmy, I mean, you were a former regional court magistrate for the criminal division. Do you think that magistrates and prosecutors have the necessary sensitivity in dealing with cases where, say, for example, sex workers have been prosecuted? And is there perhaps a way that we can look at more sensitization amongst the presiding officers?
Yeah, Chantal, I know from my experience as magistrates, you know, many years ago, we went through an intensive social context training course. And this was in Cape Town under the UCT's LRG, Law, Race and Gender Unit. And I know Swet was also part of that training. I think it's just the minds of magistrates, but you know, at the end of the day, your in terms of what you deliver your judgments is based on what the parties place before you. I think as I said, from a magistrate's perspective, I think there has been, I'm not sure if there's been ongoing, but I think there's been in at least a level of gender sensitivity training in terms of social context, you know, which magistrates underwent. From the prosecutor's perspective, I think the issue that I have with that is the reluctance sometimes to pursue based on the evidence that they have. If you look at the one case, I think the Constitutional Court case, it was Botma and Else, where the lady, she actually had to go on a private prosecution. So maybe there should be some, and I think if either through legislation, and hence I said the earlier remark was, I don't understand why sexual offenses have been categorized in terms of your bail provisions and so on for Schedule 5 and 6. Once it involves a sexual offense, irrespective of the nature, because it's been expanded, it should automatically fall into the category where you prioritize and expedite proceedings even through your special courts, and that's where the times happens with regard to recall, memory, caution rules. So we should start putting that pressure on the NPA to ensure that any cases which are lodged on the courts are then expedited with a minimal of delays, you know, because of the impact of trauma and recollection and so on the witnesses. So that's what I'm saying. From the magistrates, I'm comfortable. I'm not sure how far they've gone since then, but from speaking with magistrate friends and judge friends, I understand that there is still the emphasis on social context and understanding the different context in which we operate as judicial officers. From the NPA role, I know when at Justice College they had the role of ethics and looking at the social context aspects, but I'm not sure if that has been carried on. If my personal experiences over the last years was that there seems to be unconcern in terms of proceeding through a case to finality, especially where children are involved or persons with intellectual disabilities are involved as victims. Thank you.
Kimmy, just back to you. When we started this project with probono.org, we interviewed some legal practitioners to understand what do they understand about legislation that protects people living with HIV/AIDS. And one of the lawyers actually told us that very few legal practitioners, so that includes paralegals, know about the Sexual Offences Act, and that a victim can actually approach a magistrate for an order getting the perpetrator tested for HIV. And that's become, you know, that could actually be quite useful especially in civil proceedings if you don't succeed in criminal court. So what has been your experience with the Sexual Offences Act? And you did earlier say that it's not being used a lot, but what can we as with probono.org do to actually get that, you know, more in action?
Thank you, Chantal. I think the remedies available in terms of having the perpetrator tested for his HIV status It's provided for in the Act specifically, and even on the bail, when bail is being held, the fact that the perpetrator was HIV positive at the time would make a difference whether it's going to be a Schedule 5 or Schedule 6 offense, because Schedule 6 you'll have to meet exceptional circumstances to be released on bail. So that disclosure must be there, and if it's not there, as far as I'm concerned, the obligation is in on the state to proceed to have the perpetrator tested, so that those issues can come forward before the court from the bail aspect as well as the during the trial proceedings. But and before I even deal with the what legal advisors or lawyers should deal with in terms of obtaining, even for a civil case thereafter, obtaining the status by way of applying to the magistrate for an order to have the perpetrator tested. It's just that depends on what is the content of that affidavit that you put in. So I'm busy with an application format and the content of what should be contained in that, because even if you look at the amendment legislation, the 23 February 2020, which is basically the legislation dealing with the so-called prescription of civil remedies and criminal remedies, and where rape is one of the issues there, where you can there's no prescription on instances such as rape, but for both criminal and civil remedies. So those must be brought into the application, and the courts, I think, there's sufficient remedies available to deal with that. And I'll let pro bono have the affidavit, the form of the affidavit and the application to be made before the magistrate in terms of going forward to have the tested, especially where the NPA decides to nolli prosecute. The other issue is, and which I've been advancing, and which came out very clearly in that case of Botma and else, where the Constitutional Court, she pursued the matter several years afterwards, even while the NPA nolli prosecuted the matter to a private prosecution. So our lawyers must start getting into that realm of private prosecutions. We need as pro bono and other formats to start getting lawyers not only acting as defense lawyers, but acting as prosecutors in a private prosecution environment, where we have to advance cases where the NPA, for some reason or the other, feels that there's no sufficient ground. And for me, the reading of that Botma and Al's case really opened up your eyes, because the Constitutional Court was very clear into how the High Court, on what grounds, refused or closed the further prosecution, but how it was reopened in the Constitutional Court. So I'm saying there's many ways in which we can, as lawyers, get involved, legal practitioners, paralegals get involved in addressing social justice, in addressing the injustices that have been corrected. The criminal law sexual offences legislation provides for the testing issues. We have the civil issues in terms of the minimum prescription legislation of the 23rd February 2020, and we have already the available private prosecution scenario. We just have to have the impetus to proceed with that. Thank you.
Thanks.
Could I ask a quick follow-up question, please?
Sorry, Alice, do you have a question?
Yes, I do. Kimmy, I just wanted to follow up on this notion of the private prosecutions, and just to get you to perhaps give us a little more of your own thoughts and opinion about why this vehicle has not been used more often, and what could we do to promote its use, particularly in the context of the criminal justice system failing so many victims / survivors.
Yeah, thank you for that, Alice. From my side, I think it's because we've been so reliant and trusting of the the National Prosecuting Authority, even in the last 10 years, where there was a huge outcry in terms of how they've been doing the prosecutions, which they're supposed to be independent and carry out prosecutions. So recently, if you look at because of the frustration from the corruption angle, we started looking at people looking more into the private prosecutions environment. Basically, I think because the private prosecution from me addressing this or looking into it had an issue in terms of gathering all the evidence, using the issues of the victim impact and proceeding to instituting a prosecution in the courts. Now, for some reason or the other, people had the trust in the NPA, and they still have in the National Prosecutor. They will proceed with the matter, even in frustrating times. And I'm advocating that we should allow a space, especially where you're having sexual offenses, where victims are children, victims are persons with mental or intellectual disabilities. Because of the issues of very often they are one-on-one, the victim and the perpetrator. There's not much other witnesses available. We need to start putting pressure on the NPA to expedite that. And if they don't do it, then to prevent any further delays, we need a new new movement with regard to getting more private prosecution. The National Prosecuting Authority provides for that, Act provides for it, the Criminal Procedure Act provides for it. It is about then us linking with other evidence gathering or investigators. The SAPs must be able to give us all the investigations conducted once the NPA decides to non-prosecute. So it's a process in which we have to look at it from different angles. Who are the bodies, and then how do we enroll the case for prosecution, and then proceed by way of our attorneys in terms of the private prosecuting environment. There is a form for that. I think I strongly believe that one of the reasons is people just didn't have, because it's very difficult if the NPA decides not to prosecute, to now go to a private attorney and say, okay, I need to prosecute, and what are the costs implicated? The fact is, legal costs in South Africa, and I think throughout the world, it has been a huge hurdle to access to courts. And I think if we start through education and knowledge sharing amongst attorneys and getting the pro bono.org environment to come forward, we will be getting, even if we start training young lawyers to take on these matters, to become prosecutors and to proceed in terms of the civil prosecutions environment. So Alice, I think I've said a mouthful, but I think that is what it is. People firstly had confidence in the NPA. Secondly, they, the costs that are usually associated with proceeding privately, and also the issue of cost orders being made, and that is why the case is very important into how cost orders was granted by the Constitutional Court for the private prosecution issues that we dealt with. So we have to look at it from holistically into how we start impacting on our criminal justice system and addressing victims through private prosecutions. Thank you.
Thanks, Kemi. We've got another question here from Esmeralda Hewer. She asks, if someone is being accused of rape and the victim alleges she got HIV due to the rape, can the rapist deny to be tested for HIV? And how would the burden of proof be proved without evidence? So, for example, without proving that the rapist has HIV, in light of human rights, how would one proceed?
Chantal, as I said, in terms of your human rights and your Bill of Rights issues, there's competing interests. The legislation specifically provides for testing of perpetrators. And even if it doesn't volunteer, the test can be administered, through the exercise of reasonable force, like you would do any other test, like a drunken driving test or any other drug test that needs to be done. So that would be the one way of getting the evidence, before courts for the prosecution, and that is where we have to start using the legislation, criminal law, sexual offences act more because it's provided for there. The testing results have to be there. It's provided for. The situation is there. Let's take a scenario where, for some reason or the other, you cannot get that record. It may be a bit more difficult, but the victim may have then the issues of perhaps you can use evidence where the victim had been for a medical test recently. For some reason or the other, her test came out negative. I'm not saying it's going to be conclusive proof, but at least then after the incident, shortly after undergoing a medical test, she was proved that she's positive. So this can be used as evidentiary material. test results from there. But as I said, the issue is, and I know there's been many other jurisdictions where they're looking at the rights of the perpetrator not to be forcibly have a test. But I'm saying it has to be a balancing, and what does our constitution provide at the end of the day? Because the issues of your dignity, your personal integrity and safety, these are all non-derogable rights when viewed against the privacy issues of the perpetrator, which already are subject to limitations. So I'm giving a general view on that, but as I said, as the merits point to a particular direction, there is ways in which we can find out. For me, the legislation provides for the testing of a perpetrator, even though you may even have to go for a second test, normally a first test may not even necessarily be conclusive. You may still be, but other evidentiary material around that, like if you look at the CN case, the victim, when she went for the first test, she had a negative test, and only after realizing that the evidence was laid about the positive status of the perpetrator and subsequent tests, then only it come out that the test was positive. So from that regard, Chantal, I think it is a good, very excellent question, but I think it needs in terms of looking firstly at using our rights and the provisions of the Criminal Law Amendment Act, and then going beyond that if we say this doesn't, for some reason or the other, fit into that category of obtaining the HIV testing of the perpetrator. Thank you.
And just on that, probono.org has actually created a video around the specific sections of the Sexual Offences Act, how you bring an application before a magistrate to get a perpetrator tested for HIV. And that will be available on probono.org's website, but also on the link that we'll send you after this. And Kimi, yes, you've generously offered to do a template of the affidavit, and we'll circulate that around as soon as we get it. Thanks for that, Kimi.
Okay.
So I see we've reached our time limit, so I'm just going to hand over to Alice to do a final word of thanks.
Thanks, Chantel, and thanks, Marco, behind the scenes, who's working the IT for us. I just want to, take this moment to say thank you very much to our guest speakers. It's been a very informative session. It's a depressing topic, I must admit, but these are the realities that we're dealing with, and the ways in which we need more pro bono work around these issues is so clear. And I hope that with the participants who are here, that they will think more about the ways in which they could provide and assist around these issues and provide pro bono legal services, but also act as evangelists with their colleagues in terms of the provision of pro bono legal services for victims of sexual offenses, for sex workers, for people, all the key and vulnerable populations. So basically, I just want to say thanks so much to Kimi, to Emily, to Sheena for their contributions and for the work that you do every day, day in and day out. Thank you so much.
Thank you, Alice. So just for our viewers, probono.org has actually been updating its website to include resources that lawyers that are interested in HIV/AIDS work can use. So if you just, so Marco's actually just shared his screen. And if you go to the website and you go, so he's just actually showing where probono.org's been posting the videos that you can use. And then if you go to media and you go under resources, then just under the HIV, AIDS and TB tab, you'll be able to find the resources that have been posted in the meantime. So for now, that's included some national law and policy, and then the key cases that have been decided over probably the last 25 years in respect of HIV/AIDS. And then there's also some guides which we've linked to other websites, as well as current research. So we really hope that you can use that. and that it'll make your work a bit less. But also feel free to email the staff at probono.org if there is a specific issue that you would like to work on, and we'll see how we can get the resources to you. So thanks to everyone so much for joining us today. We will be having more of these events, whether it's going to be online or in person. Probono.org will be going throughout the country to be hosting these events. So we hope to meet you soon in the flesh. So thanks so much for joining us, and please have a lovely weekend. Thank you. Bye-bye.